This is Holly Sutton. I am the former chair of the Employment Practice Group and currently the co-managing partner at the firm, and still very much practicing employment law, which I've done for decades now. And I am very pleased to introduce my partner, Rebecca Stevens, who is also a full-time employment practitioner. And Rebecca actually was sort of the brainchild behind this webinar, which is the first in a series of webinars we'll be doing this year. And we find these can be a little more interesting and useful than just the email client alerts that we've done historically. So we're excited for this, and our next one will be coming up in May. So keep your eyes out for that. Should I hand it to you, Rebecca?
Sounds great. Well, thanks everyone for joining us. We've got a lot to cover today. Anyone who's been following the news knows there's been a lot of activity from the EEOC in the last few months, and so we're excited to delve into that today. Today's agenda will include some key updates to the EEOC guidance and regulations, the impact of President Trump's executive orders. We'll cover some of the new litigation that's been filed by the EEOC under the new administration, as well as some existing litigation that's been dismissed. Some strategies for managing legal risk where state and federal EEO laws may be in conflict or at least in tension, and then some recommended updates for employer policies and programs. The slides will be made available to all participants after the presentation. There's a lot of material here, so we won't be able to cover every single order or issue in great detail, but you will have copies of the slides. And we encourage people to share any questions in the chat, and we'll review those as the presentation proceeds and try to answer them as we go. And then we'll also try to save a few minutes for questions at the end. But thank you all again for joining us.
Great. Okay. Well, let's dive into kind of what's going on at the EEOC. And when President Trump won the election, we were anticipating that Commissioner Lucas would be appointed chair. She was appointed during President Trump's first term. What we did not anticipate was that President Trump would remove two of the commissioners who still have years left in their terms. This is unprecedented. Traditionally, because the commissioners are appointed by the president and confirmed by the Senate, they were allowed to serve out their terms. We are a new territory now, and in fact, one of the Biden appointees, Jocelyn Samuels, who was unceremoniously removed prior to the end of her term, has filed suit in the Washington, D.C. District Court, alleging that the executive branch does not actually have the power to remove the commissioner. So we'll see how that plays out. But in the meantime, where we are is we do not have a quorum on the commission. Where there are only two commissioners in the seats right now. It is quite possible that soon the president will appoint new commissioners, and we know that the Senate has, for the most part, been approving the White House appointees. So we might end up with a quorum in the near future, but for now, they're limited in what the EEOC can do. It cannot vote on rule making. Is under its own rules not able to rescind guidance documents or issue new policies. As Rebecca's going to get into in a little more detail, we're seeing kind of a runaround on that. And we have had a lot of new sort of guidance looking docs come out that we're going to talk about. But technically, those need to go before the full board, and they don't have a quorum. But sort of in terms of what this means for employers, out here outside the Beltway, the EEOC continues to accept and process charges and conduct hearings before administrative judges, file lawsuits, issue subpoenas. So a lot of this is kind of removed from what many of us are dealing with on more of a day-to-day basis. At the same time, as we're going to talk about, we are seeing very clearly a change in the enforcement actions going on in the regional offices.
So Acting Chair Andrea Lucas has been very clear about her stated priorities. So as Holly mentioned, while the EEOC doesn't have a quorum, they currently can't issue any new guidance or regulations in these areas, but these will inform the types of charges and issues that they're prioritizing and investigating and filing lawsuits over. So these are in Lucas's own words. Her priorities include rooting out unlawful DEI-motivated race and sex discrimination. So we'll talk in detail today about what this means for DEI programs. Protecting American workers from, quote, anti-American national origin discrimination. Defending the biological and binary reality of sex and related rights, including women's rights to single-sex spaces, and protecting workers from religious bias and harassment. So this is what Acting Chair Lucas has said is going to be her focus. In addition, while they haven't been able to actually rescind any official regulations, they have removed guidance from the webpage that was issued under previous administrations. So there used to be a number of pages on the EEOC's website related to the U.S. Supreme Court decision in Bostock versus Clayton County, which found that Title VII prohibits discrimination based upon sexual orientation and gender identity. There were also pages regarding protections for LGBTQ workers, and there were pages with information about how the use of artificial intelligence tools in employment decisions could result in unlawful discrimination. All of these items have now been scrubbed from the EEOC website, which obviously contributes to an inference that they will no longer be prioritizing enforcement on these issues.
So what we got in their place are some technical assistance documents regarding DEI programs, including one that's entitled What to Do If You Experience Discrimination Related to DEI at Work, and one, What You Should Know About DEI Related Discrimination at Work. So both of these, I think, can fairly be described as messaging to employers and employees that there's some risk now associated with DEI programs. And in fact, there's a special contact email now set up for federal workers to report what they may feel is harassing DEI programs, unlawful DEI programs. And we don't have a lot of guidance on what the current EEOC or the administration views as unlawful DEI. And we think that's probably intentional. It is having a very much a chilling effect in terms of what employers are doing with DEI. And, in some ways that makes sense because these programs were set up in part because the EEOC, along with the case law and the state regulatory agencies, really encouraged them. And I think very few employers want to be in a position where they're promoting DEI and then they now become the target of an EEOC action. So we want to kind of dive into, what's unlawful DEI. And I'll just share with you, at the outset that you're seeing a lot of changes, certainly in how DEI programs are being messaged. So, Target's getting a lot of press right now because they pulled back on all their outward-facing DEI messaging. They have been the subject of a boycott. And the latest article on that in Newsweek shows that despite rising numbers in going up to the boycott during the last 10 weeks, those certainly in-store traffic has dropped something like 7%. So The stock is also down, but everybody's stock is down. So I don't know, we can take a lot from that. But right now we're seeing these tensions between, what employers are deciding to do. Certainly in the legal industry, there's actually law students out there who have set up a tracker. And that is tracking what top law firms are doing with their DEI. And I think it's fair to say that most of the large law firms are no longer using the word diversity. And there's some press about what's going on at the federal level as well. Anything with the word diversity in it is causing consternation and fear that this might make these programs a target. And so we'll kind of come back to that and what some of the new language is in a couple slides. But for now, looking at these guidance docs, they certainly identify the use of any quotas or balancing of an employer's workforce as an example of DEI-related discrimination. And we have always been clear with our clients that quotas are, definitely not permitted under current law. And, it's a facial discriminatory action, except in very specific circumstances. So, there were certain employers, many of these were, frankly, municipalities like fire stations, firefighters, who just traditionally had never hired women and minorities, and they were subject to court-ordered injunctions that required them to where they agreed to meet certain quotas. But in the absence of that sort of structured program, quotas have always been very risky, along with this idea of, kind of balancing your workforce. So those, I think pretty much any employment lawyer you talk to is going to tell you those continue to be problematic and not something, you want to be doing in your hiring process. The guidance also states that, certain types of DEI training could give rise to claims for hostile work environment. And they cite to a couple of cases, and I just wanted to give some updates on those cases because as it turns out, one of them is pretty extreme. Actually, both of them are pretty extreme, but one of the cases they cite to against the Secretary of Transportation, this is the Hartman case, is just one of these, bad facts make bad law cases. And in this training that was conducted, the claimant alleged that he was required to run between two lines of women lined up, who then physically assaulted him, including touching his genitals. And I guess the whole thing was set up to sort of mimic what happened at Tailhook, which some of our more seasoned participants might remember, a big scandal involving the Navy and the Marines that took place way back in '91 and involved at a big conference in Las Vegas that ended up resulting in like 60 women claiming they'd been sort of forced to run down this hallway. So I guess this trainer thought that somehow there was something to be gained by forcing men to experience this. This claimant, brought this claim, and there were some other terrible facts that you're welcome to look up the Hartman case. And on an MSJ, a motion for summary judgment, all of his claims were denied except for the gender harassment claim. So, that I think gives you a sense of what the courts have said are unlawful DEI. And I think most of us would agree that sounds like unlawful conduct. One of the other cases that was cited was by a professor at Pennsylvania State University, who claimed he was the subject of discrimination and retaliation because he participated in their training programs in which some of the content included language that white teachers are a problem. But there, just last month in March, the district court actually granted Penn State's motion for summary judgment, saying that no reasonable jury could find that his attendance at this DEI training could be sufficiently severe or pervasive to prove a racially hostile work environment. So it's kind of interesting. I think since the case was cited in the guidance doc, the judge has actually ruled in the other direction. So finally, one last case I want to mention on the DEI front is a case that we've been following for a while, DMART v. City of Seattle, which was filed a few years back. Seattle had a pretty comprehensive social justice training program that it required its employees to attend a couple times a year, although importantly, there were no penalties for failing to complete them. And there was some pretty extreme language used in these trainings. The plaintiff alleged that that as a white employee, he was called a colonist, and that it was stated that he was to blame for all injustice in the United States. And there was some other kind of tough language. I guess they referred to white employees as cannibals and white devils, just really kind of language that I think Rebecca and I would be really surprised to see in any sort of thoughtful DEI training. But interestingly, in that case, and we watched it because we thought it might get thrown out at the pleading stage, it did not. But ultimately, just in February, the court granted summary judgment against the plaintiff and said no reasonable juror could find that the city acted with a discriminatory purpose in sponsoring these programs. So that was quite an interesting outcome there. And I think what our takeaway is that it's really hard to have a bad enough DEI program to create a hostile work environment. But what's really important for this group is, well, but am I potentially going to be targeted by the EEOC, even if the courts and the case law doesn't support that? And I think you will find there's a lot of fear out there, which is why so many law firms are rebranding and Target's rebranding, a lot of people pulling back on their DEI programs. So getting kind of a little more into what the EEOC guidance says. So they say they are lawful as long as they do not take any action motivated in whole or in part by an employee's race. So again, kind of this theme that any consideration of race or gender or other protected characteristic is viewed as unlawful under the current guidance, and emphasizing that it's not only those in the minority group or the diverse group that are protected by Title VII, but also the majority group. And so that's what we have traditionally thought of as reverse discrimination. And there has been some interesting development. I mean, there were some cases that held for a while at the appellate court level that you actually had to prove a higher burden to prove reverse discrimination. We think that issue is going to go between the Supreme Court soon, and based on recent rulings, I think it's likely that distinction will be overruled, and that all discrimination, whether it's reverse or a protected class, is going to be judged at the same standard. We also mention here that there's a Supreme Court case that came down last year, the Muldrow case, that held that any sort of change in the terms of employment could be sufficient to show some injury or some harm to support a discrimination claim. So, traditionally we think about terminations or demotions or failure to hire, but this case actually involved a change in a shift. And so this Muldrow holding also has a lot of us a little bit concerned about, the ability of a plaintiff to show hostile work environment or discrimination based on something that's far short of a firing or a demotion. So then I'll just give you some of the examples that we have on DEI-related disparate treatment. That is access to training, so including leadership development programs. And I know there have been, these have become very common, and these kind of diversity leadership programs. And those are specifically called out as disparate treatment and not permissible under the current EEOC guidance. Access to mentoring, sponsorship, workplace networking, internships and fellowships that are specifically limited to protected classes, and selection for interviews, including placement or exclusion from certain slates. So those are, pretty wide-reaching guideposts on what's permissible or not. And I think we're going to talk a little more about what employers are doing sort of in response to this guidance. So I think, is this still me, Rebecca, or am I handing it over to you? Okay.
Yeah.
So I'm talking a lot. You guys are getting to hear a lot from us. So one of the, common justifications that we've seen for efforts to increase diversity at different, by different employers is we want to have a diverse workplace that reflects our community, reflects our client base, etc. And, given the sort of the intent behind these programs, and the kind of lack of enforcement at the EEOC and CRD levels, they've been relatively low risk. And now I think that's going to change. So when we are doing our hiring, when we are setting up our processes, you really need to stay away from targeting specific candidates or favoring specific candidates based on their protected characteristics. There is a carve out for bona fide occupational qualifications in very limited circumstances, but those are not going to apply to most employers. And so then the question is, well, what do we do about our affinity groups? And certainly those have been, I think they're very common. They've been going on, many of these affinity groups, for generations. And the EEOC is taking the position that, sort of limiting participation based on race, sex, or other characterization that affects an employee's status or deprives them of opportunities is unlawful. And that includes something as simple as, making available company time, facilities, providing a lunch. So this is a real big one for employers in terms of what are we going to do about our employee resource groups or affinity groups. Again, if you look at the large employers, you'll see most of them are disbanding those initiatives. And in part because demand letters went out from the chair of the EEOC. I call it a demand letter, but basically a letter requiring them to report all of their DEI. This went out to about 10 of the top employers, the nation's top employers, requiring them to report what they're doing in these areas. Now, it's pretty clear, and the attorney generals have pointed out that there's no authority for this at the EEOC level, but what employer wants to have to respond to those kinds of letters and be in the crosshairs of the EEOC? So we're seeing many employers pulling back on those affinity groups or making them available to everyone. Which is, kind of a nice compromise. And And we can talk a little more about that as we get to sort of, next steps and recommended actions.
Okay, so moving on from DEI programs, focusing now on the Pregnant Workers Fairness Act. Hopefully everyone here knows that this was a federal law that was passed in 2023, requiring accommodation of known limitations related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions. In 2024, last year, when the EEOC still had a quorum, they issued implementing regulations regarding the PWFA, including a very broad, very expansive definition of the phrase related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions. And the guidelines that came out last year from the EEOC were very clear that this wasn't meant to be limited just to a current pregnancy or a very recent pregnancy, but it was essentially every possible condition related to the female reproductive system. That included things like past pregnancies, potential or intended pregnancies, infertility and fertility treatments, the use of contraception, endometriosis, things related to menstruation. Very controversially, abortion was included in the definition. So it was an extremely broad definition and required that employers make accommodations for all of those types of conditions. At the time that those regulations came out, our current acting chair, Andrea Lucas, who was then just a commissioner on the EEOC, she issued a statement, a very lengthy statement, basically supporting the law generally, but arguing that the regulations were overly broad, and particularly taking issue with the definitions of all of the conditions that employers should have to accommodate. And in her view, the law should be limited only to a current pregnancy or a very recent pregnancy in terms of lactation and breastfeeding accommodations, or maybe postpartum depression or something along those lines. But she was looking at a very narrow definition of the types of conditions that would fall under the law. She has recently issued a statement reaffirming that position that she expressed last year, and stating that once the EEOC has a quorum, she's intending for them to basically reconsider those regulations and probably revise the definitions under the PWFA. So for now, nothing has changed. Those regulations are still binding on employers, still valid law. But I think we can expect that once they have a quorum, and assuming that that quorum leans politically the way that she does, we might see some changes, kind of dialing back the scope of the regulations for the PWFA. There have also been a number of recent executive orders, which I'm sure everyone has seen the news of. And I want to just pause here for context. So these executive orders, President Trump cannot issue executive orders that are binding on private employers. These are executive orders that direct how federal agencies and the executive branch will apply and interpret and handle certain issues. However, these are relevant because some of them provide directives to the EEOC as to how it will handle employment issues that come up from private employers. So to be clear, no private employer is directly implicated by an executive order, but to the extent these orders are filtering through the EEOC, that's where you'll see the application to private employers. So some key executive orders are described here. There were a couple of executive orders related to DEI, no surprise given Holly's earlier presentation, but basically eliminating DEI programs from the federal government, and then requiring agencies to take actions to, basically reduce DEI within their territories and their jurisdictions and scopes. So the EEOC is already taking action here, as we've seen with the two technical documents that Holly described. Gender identity is a huge issue for the administration. So one of the executive orders states very clearly that the federal government's policy is to recognize only two sexes, male and female, as assigned as conception, basically eliminating the concept of gender or gender identity or gender expression from the federal government. And this order directs the EEOC to prioritize investigations and litigation enforcing rights and freedoms relating to, quote, the binary nature of sex. In particular, the EEOC has been ordered to rescind portions of guidance that was issued in 2024 related to harassment in the workplace. And within that 2024 guidance, there were a lot of examples related to gender identity, including stating that harassment could include misgendering a worker, preventing an employee from accessing a bathroom that aligns with their gender identity, or virtual harassment on social media. There were also some guidelines within in that guidance about how to balance anti-harassment laws with religious accommodation. So to the extent you have employees saying, well, my religion prevents me from recognizing this transgender employee or using the pronouns that this person has asked me to use, that there was some guidance within the EEOC's 2024 harassment guidance on that particular issue. And the EEOC has now been ordered to rescind portions of that guidance. Now, again, they don't have the quorum yet to do that, but we expect that once they do, that's going to come out. And then the other thing of interest to employers, and I think this is really important, is that Acting Chair Lucas has says that charges that implicate issues of gender identity, gender expression, transgender rights, things like that, will actually be elevated to the EEOC headquarters for processing and review. So to the extent that California employers were feeling some solace that maybe charges on this topic that were filed in San Francisco or Los Angeles might not generate the type of attention from the EEOC employees in those offices, unfortunately, those charges, at least per Andrea Lucas, are going to be elevated to the DC headquarters and probably prioritized there in terms of investigation and review and actions. There have been a few other executive orders that are relevant here. Again, with DEI, there have been several orders on this. We don't need to go through it again, but the agencies have been ordered to take steps to sort of eliminate DEI within their purview and their jurisdictions, including each agency is required to identify, quote, the most egregious and discriminatory DEI practitioners in each sector of concern, and then also propose up to 9 civil compliance investigations of large companies related to DEI initiatives. So they're very, very focused on this. And then there's an executive order also confirming that the administration is committed to combating anti-Semitism and requiring federal agencies to submit reports as to ways that they might curb or combat anti-Semitism. So I think we can expect that if charges are filed with the EEOC relating to allegations of anti-Semitism or harassment based on Jewish religion, those might be prioritized for investigation and enforcement.
And some other litigation updates on the EEOC front. And again, these are changes we've seen since the new administration took office. In February, they settled a case with a resort in the U.S. territory of Guam that was alleged to have given more favorable wages and benefits to Japanese employees. So again, this is a little outside the normal pattern we see. And this was the minority workers were alleged to be receiving better benefits, more favorable benefits. And this was kind of a headliner for the EEOC that they're about, protecting American workers from anti-American bias. We also saw that they dismissed 6 lawsuits that had been filed during the Biden administration alleging discrimination based on transgender status, noting simply not that the law has changed, because in fact the law has not changed, but that continued litigation is untenable, based on the change in administration. So sort of owning that this is a political decision. Now, so what's going to happen to these cases where the EEOC has been litigating on behalf of a transgender employee, and now they have voluntarily dismissed? And some of those cases, the plaintiffs have asked to intervene and continue the litigation on their own behalf, presumably with private counsel, civil counsel. And in another, the ACLU has asked to intervene. We expect, again, because the case law hasn't changed, that these intervention motions will be granted. So, your takeaway here is not that, that we think there will be less litigation in the, protecting transgender rights, but that more likely that litigation will be venued somewhere other than the, via the EEOC. So either through civil actions or through the local state agencies. And of course, out here, that's the Civil Rights Division, which is quite active in this area.
Okay, and then another aspect of EEOC litigation, they've confirmed that pregnancy discrimination does remain a priority for them. Just in the last few months, they've announced 2 settlements and 1 new lawsuit filed this month regarding allegations of refusing to schedule and then firing a temporary worker upon learning she was pregnant, refusing to allow a worker to return to work after maternity leave, and refusing to allow a worker with a high-risk pregnancy to work remotely during the pandemic. So I think we'll continue to see a lot of activity from the EEOC in the area of pregnancy discrimination, with the caveat that given Acting Chair Lucas's statements about the scope of what she believes should be protected under the pregnancy discrimination laws, it's going to be more limited to just a current pregnancy or a very recent pregnancy. You will not see the EEOC taking this sort of expansive view of all of these other conditions that are more tangentially related to pregnancy.
So, okay, so what does this all mean for those of us out here, trying to run our businesses and stay on the right side of the law? Certainly, I think everyone would agree, we continue to avoid any sort of unlawful discrimination based on race, color, religion, sex, and national origin. And one of the concerns that many of us have is that in light of a lot of headlines and discussion that's sort of anti-DEI, that the messaging will come through in a way that's inaccurate, that the traditional discrimination claims are now a lower risk. That is absolutely not the case. And given that these laws all carry with them attorney's fees, they continue to be very attractive to private plaintiffs. So even if the claim themselves itself might not appeal to the EEOC, and particularly something involving, a transgender claim might not be picked up by the EEOC, very much still unlawful under case law and Title VII. We wanted to mention that, it's a fairly recent Supreme Court case, the Bostock case, that confirmed that sex, and that is, sex as it's referenced in the statutes, includes gender identity and sexual orientation. So the case law is there, and it just may be that we're seeing a shift in how these claims are being prosecuted, and away from the EEOC and more towards the state agencies, the private practitioners. Some of the language we see in the cases that are granting summary judgment on these DEI related claims and denying these claims and coming down in favor of the employer is that these kinds of anti-harassment, anti-discrimination training programs have long been viewed as an important part of an employer's efforts to avoid discrimination and reduce unlawful discrimination. So we want to be really careful about pulling back and reversing course on these programs to the extent they were helpful in avoiding what I will now call sort of traditional discrimination in the workplace. And, you know, well, I think we're going to see some headlines and maybe more of these reverse discrimination claims. Numerically, as an employer, your risk is going to continue to be much higher for claims by these minority groups and, you know, and protected classes. So I want everyone to just keep their eye on the big picture here in making decisions about which programs you're going to continue and which you're going to discontinue. Certainly will mention that, you know, we continue to have in California mandatory anti-harassment and anti-bullying programs. So you definitely want to comply with that. I mean, I think when we look at some of these bad facts cases, often what happened is the folks running these training programs probably weren't properly reviewed by legal, frankly. And, you know, there's really no licensing requirements for these trainers. So I would say, and have said to clients for a long time, be very careful with these trainings and thinking about who's conducting them, what the content is, and whether you're making it mandatory or optional. And certainly, I think considering not requiring people to go who don't want to go is a good call. One of the classic areas where we see conflict is people with religious beliefs that are anti-LGBTQ. And that's an area of conflict we've been wrestling with for a long time in the workplace. Certainly now, the EEOC is going to be more, I think, friendly to these religious accommodation claims, even though very recently we've seen claims that, you know, programs that simply trained on respectful conduct in the workplace, it, you know, is not grounds for any sort of religious discrimination or failure to accommodate claim. You know, I think it's fair to expect that that may change at the EEOC going forward. So these are some of the changes that we're going to be counseling our clients and working with our clients on. But certainly any sort of guidance materials or objectives you have that require a quota, where you're making hiring decisions based on a protected class continues to be problematic. And would, you know, would probably not have passed muster pre-Trump administration and certainly won't now going forward. I think I've covered, yes, let me turn it, let's go to the next slide here. So we did some, Rebecca gets all the credit for this, some comparisons so that, you know, the employers who are kind of probably feeling a little bit whipsawed here back and forth, just to show you, kind of break it down. So the federal policy is that the administration is against unlawful DEI. We're not getting good definitions of what unlawful DEI is. We think that's purposeful. California law and the attorney generals, including 15 other states, have said, we think DEI training and policies are a lawful and important tool in the workplace. So we have a pretty direct tension there. And as I said, making sure that you're giving special thought to your programs. Certainly at this point in time, it's easy to recommend opening up your ESG programs so that anyone may attend. That's going to hit differently in different workplaces. Smaller workplaces, I think it's a little easier to roll that out. Larger workplaces, it's going to be potentially harder. You know, what I am hearing is that some of these programs are kind of going underground and they're still happening, but they're happening in a much less formal, organized way and sort of what I would call almost old school mentoring. Hey, who's available to meet up after work today? Putting these requests out to smaller groups informally. We'll see. It's early days. The EEO technical assistance documents indicates again that, certain training may be grounds for a hostile work environment claim. And as I said, the case law on that is, I think it's helpful to look at and understand how extreme, how much of an overcorrect we saw in these trainings that were ultimately examined by the court. But right now, the case law really is favoring what I would call kind of respectful DEI training that helps us identify unconscious bias. I think it's going to be very tough to win a hostile work environment claim on those kinds of trainings. At the same time, I think we're going to see a big trend where employers are pulling back from those trainings. California law does require the anti-harassment and abusive conduct training. So, certainly all of our California clients will want to continue to comply with those training requirements. And in fact, in light of the change going on right now, might actually want to put a little more thought and care into those trainings to the extent you're relying on them more and less on other DEI programs.
Before we move on from the DEI topic, I did just want to make another point that Holly and I discussed a lot as we were preparing for this presentation, because I think many employers have spent the last many years developing, implementing, spending resources, implementing thoughtful DEI programs, whether that's training, whether that's mentorship, all sorts of different things that employers have implemented. And I think we are certainly seeing the intended chilling effect, where some of them are either taking them underground or eliminating certain things or renaming them. But I did want to emphasize that just wholesale eliminating DEI is not without risk, right? Because employees have come to know those programs and participate in them and become invested and involved, and they spend their time and resources building these things out. And it's part of their workplace culture and community. And to just completely eliminate all of those programs at the drop of a dime is also going to create risk, right? At minimum, you're going to see employees expressing opposition to that decision, or openly criticizing or raising concerns internally about whether you really care about diversity, equity, and inclusion, or this was all just for show. We've certainly seen, examples of law firm associates resigning from their firms over the way that they've responded to some of these issues coming out of the administration. And so the easy answer is not just, okay, let's just eliminate all of it, because then I think you're opening yourself up to, claims of discrimination from the employees that had been participating in those programs. And so there's a lot of thought that has to go into what is the right approach, kind of balancing the different issues at play. And figuring out the way to move forward. As Holly mentioned, some employers are just getting rid of those things. Some of them are renaming them. Some of them are taking them underground. Some are opening up those resources to a broader group of employees. It sort of depends on your workforce, where you want to take the risks, where you want to reduce the risks. But it's a very careful balancing approach that needs to be taken here.
Yeah, and I'll just add, if people are interested in, what the renaming looks like, we are definitely seeing a big move away from the term diversity. We're seeing more engagement programs, culture and inclusivity programs. Opportunity seems to be a word that is okay in the current administration. It's just diversity that seems to be the real problem. I'll just share as an aside, there's a lot of attention going on right now to I think billions of dollars in federal grants that are being canceled at various universities. And it seems that they just did a search of every grant, and anything that referenced gender, diversity, even indigenous, those were just canceled without much thought. I know somebody who was working on a grant involving indigenous grasses, and they had their grant canceled, presumably because it had the term Indigenous in it.
Okay, so moving on to these issues with gender, as you've heard, the EEOC and the federal administration, their position is there are only two binary sexes assigned at conception, and they believe in the importance of separate private spaces based on the sex that was assigned at conception. I have to say that this policy is completely inconsistent with both federal and state law. So any employer in the state of California that decides to adopt this interpretation and eliminate protections for people of differing gender identities, gender expression, sexual orientations would be taking a lot of risk. We've got the federal Supreme Court case in Bostock, which confirms that Title VII prohibits discrimination based on sexual orientation and gender identity. But California law, the Fair Employment and Housing Act, has long prohibited discrimination, harassment, and retaliation based on sex, gender identity, and gender expression. So employers in California must comply with the FEHA on that point. The CRD, when it comes to the bathroom issue, which, as we know, the issue of which restrooms transgender employees can use has been a sort of hot topic with the administration as well. The California Civil Rights Department has issued regulations confirming that transgender employees must be allowed to use the restroom that corresponds to their gender identity. They must be permitted to choose the restroom that they want to use. I think here we might run into some tension, right? Because we've got California law making very clear that employees must be able to choose the restroom that they want to use based on their gender identity. Federal law is saying, we support people's ability to file charges based on having to share a bathroom with somebody that they don't want to share a bathroom with. And so this is an area where there's going to have to be some careful thought if you get escalations on this point. The CRD regulations do say that individual restrooms, individual stalls could help resolve this issue. If that's within your facilities, that seems to be a pretty straightforward solution. Obviously, not all facilities have that option. So the CRD's other suggestions are locking stalls, staggering schedules, trying to figure out a solution that respects the privacy of all employees. But this one is going to be, I think, a little tricky because it's one of the areas where there's a direct conflict between what the EEOC is saying and what California law provides. The Pregnant Workers Fairness Act, again, as we've discussed, Acting Chair Lucas believes that the definitions under the PWFA are too broad, that the law should be limited to a current or very recent pregnancy. Within California, that's not going to make a big difference in the way California employers have to address issues relating to pregnancy. There are a lot of protections for different things. So, for example, the FEHA requires employers to provide time off for reproductive loss events, which includes a miscarriage, a stillbirth, a failed adoption, failed surrogacy, or unsuccessful fertility treatment. The FEHA also prohibits discrimination based on reproductive health decision-making. So again, we've got in the state of California more expansive protections for these conditions related to pregnancy, even if not related to a current pregnancy. The FEHA definition of disability requiring accommodations has always been broader than under the ADA. And so it's likely that many of the conditions that Acting Chair Lucas feels should not be covered by the PWFA would be covered by the FEHA. So things like endometriosis or, very, associated conditions of the female reproductive health system likely could qualify as disabilities requiring accommodation under the FEHA, even if they are removed from the PWFA regulations. And then finally, in California, pregnancy disability leave is available for pregnancy, childbirth, or related medical conditions, which expressly includes the loss or the end of a pregnancy and recovery from the same. And so one of the big areas that conservatives have been challenging under the PWFA is the inclusion of abortion in a condition that needs to be accommodated under the PWFA. But at least within the state of California, I think it's pretty clear that state law would require employers to accommodate that. Now, I will take a step back and say I think it's very unlikely that employers would be made aware of an employee that's experiencing or undergoing an abortion. I think it's more likely that somebody would just say they need time off and provide a sort of vague medical note. But to the extent it comes up, it's something that probably needs to be accommodated within the state of California, and the law prohibits discrimination based on that decision. And then one area that's kind of coming down the pike, not really here yet, but something of interest to the audience, is that the EEOC under the Biden administration had issued some guidance related to the use of artificial intelligence in employment decisions, and specifically that particular tools that are relied upon and that utilize AI, for example, in screening out resumes or identifying employees for promotions or things like that, could result in discrimination if not properly monitored and without appropriate safeguards. Under the Trump administration, the EEOC has removed that guidance from its website. So we can expect that the EEOC is no longer going to be focused on that issue. However, the California Civil Rights Department is actually close to finalizing some regulations relating to the use of AI in employment decisions, basically just confirming that it can give rise to discrimination claims if the AI is not used carefully. Some of the examples that are provided by the CRD are things like tests that measure an employee's response time to something on the computer, or speed of responding to something. That might support a disability discrimination claim if it tends to screen out people who have certain medical conditions or disabilities. They also cite as an example AI tools that screen out applicants with certain scheduling restrictions. So to the extent an employment application requires applicants to confirm whether they can work a certain schedule or they're available at certain times, and then screens out people that can't, that could result in discrimination based on religion, disability, medical condition, potentially other protected characteristics. So these regulations have not yet taken effect, but we expect that they will soon. And so to get ahead of it, I think employers should look at the proposed rules, assess whether they're using any AI-related tools in hiring or other employment decisions, and then make sure that they're kind of reviewing, evaluating, and incorporating appropriate safeguards with respect to any decisions. And one of the express ways that employers can defend against claims under the new rules would be by showing that they took proactive efforts to evaluate those AI systems for potential bias, and that humans are actually vetting and finalizing any decisions. It's not just relying on machines.
All right, so I think we're at time, and luckily, I think we've sort of we've gone over our recommendations as we work through. I mean, one point that we came up in the chat, and Rebecca and I have both mentioned, is this is the rock and the hard place situation where completely reversing course on your DEI programs has a cost. So this would be, I think our advice would be to just take a careful look at it, possibly with counsel, and think about, what, if any, changes you want to make to those programs. Rebecca, did you have any more you wanted to add?
No, I think that's it. I will reiterate that the slides will be made available to participants. So we will distribute those following today's session. If anyone has any additional questions, feel free to add them in the chat. I think I've got a couple more minutes to stay and answer questions that come up. Or feel free to follow up with us directly via email if you'd prefer to discuss privately.
Yeah, thanks. And thanks everyone for joining us. It was great to have you all.